another. Well, before we begin, may I just make it clear that the court proposes to make an anonymity order in the same terms as it was made below, that no one shall publish or reveal in connection with these proceedings any information which identifies or any information which would be likely to lead to the identification of the appellant, the school in relation to which the second respondent was previously the governing body, any child attending that school, or the first respondent local authority. Thank you.
My lady, I'm grateful for that. The draft was kindly provided by your learned registrar, and certainly both parties are more than happy with the contents of the draft. We're grateful. My lady, my lords, I appear for A, the appellant. My learned friends, Miss Hannett and Miss Bickery, appear for B and C. The court should have one core volume and a second volume which comprises solely Appendix A, sorry, Part 2 of the appendix, together with 3 volumes of authorities.
Well, some of us have also got the contents of the core volume in separate documents, which is how we prefer them. So, anyway, worry not, we will... I'm sure we have the papers.
We do.
I'm grateful, my lady. One further document should have been handed forward during the course of yesterday, which is a document produced by the respondents titled Safeguarding Children and Safer Recruitment in Education. This document is to be placed in substitution for the existing document at tab 46 of volume 3 of the authorities.
Okay. 346.
Thank you.
And will it be supplied in electronic form as well?
I think.
Lady, I think it was supplied yesterday.
Yes, I think it was.
In a PDF.
Thank you.
My lady, my lords, the focus of A's appeal lies, as will have been apparent from the Court of Appeal judgment and the prior employment appeal judgment, very much with the first of the appellant's grounds of appeal, namely whether or not the employer had reasonable grounds upon which to sustain the belief that A had committed gross misconduct when the employer assessed the reasonableness of A's dismissal within the meaning of section 98(4) of the Employment Rights Act 1996.
Isn't there a prior question, which is whether her failure to disclose was or was not misconduct?
My lady, yes.
And who is the judge of whether it was or was not misconduct? The Birchall test obviously applies to whether or not misconduct was committed and whether dismissal is a reasonable response to that. But does it apply to the definition of misconduct in the first place? There's nothing in the statements, the quotations about that, which suggests that it does. Is it not a matter of law, basically the contract of employment, as to whether or not something is or is not misconduct? Now, the employer can define in their contract of employment what it is that they think is misconduct, but does the question of reasonable grounds to believe come into whether or not it was misconduct? Because your principal case is it wasn't misconduct, isn't it?
My lady, yes, it is. That the failure not to disclose...
Failure to disclose this particular association was not misconduct. That's your principal case, isn't it?
My lady, yes.
And I'm merely asking whether, as a matter of law, that is to be tested by whether the employer had reasonable grounds for believing it to be misconduct, or thinking it to be misconduct, because belief doesn't come into it, or defining it as misconduct, or whether, in fact, that is an objective question to be defined by, basically, by the terms of the contract of employment, express or implied.
My lady, my answer to that is that it does fall to be considered whether or not it is misconduct. And in a sense, that question, I think, has been slightly enveloped within issue 1 and the question as to whether or not there is a duty. If there is a duty, does the action of the person exercising the duty, effectively in this case A, fall to be considered as misconduct by reference to the particular facts? And it is a fundamental part of A's appeal that by electing, as she did, not to make disclosure in light of the circumstances of the situation she found herself in, that didn't constitute misconduct. My lady, I hope that goes some way to answer your initial inquiry.
Well, my initial inquiry was prompted by the thought that, in general, this court is concerned not with the particular facts of particular cases or the particular decisions on the facts that have been made anywhere. We're concerned with points of law of general public importance. And that's the point of law of general public importance that seems to arise in this case, as to who decides what is not, what is and is not misconduct.
My lady, yes. And I mean,
you say it's an objective question, it's not just the employer.
Yes, and
although that's not the way you put it when you first started, which is why I was challenging you.
I hope my response didn't occlude the point, because from A's perspective, it has always been seen as part of the appeal that there has been a point of public interest, in so much as what is the extent of this particular duty, and one sees that in the examples of my Lord Justice Floyd at paragraph 69 of his judgment, where he sets up the paradigm example of when there would be no question of not making a disclosure, when the teacher is aware of an employee in the school who has a conviction of offending, and the less clearer examples which he attributes A's case as falling into.
But I've taken you off your course far too long, Mr. Palmer. Please do carry on.
I think in essence, my lady, we probably come back to this point in any event, because as an opening position, we say the relevance, in a sense, of how the duty is determined, really, starting point is at paragraph 26 of the Employment Tribunal judgment, which is to be found at MS 176. And in particular, approximately halfway down that paragraph, the sentence beginning, "We consider that it is obvious that for a head teacher to have failed to disclose such information to her governing body, whether or not it is expressed in the contract of employment or not, is a matter of misconduct." And we inevitably say that this is the fulcrum of this appeal, because essentially that reasoning, which was in turn adopted by the Employment Appeal Tribunal and refined variously by the majority in the Court of Appeal, continues to hold a position which denotes the absence of any proper reasoning as to why the duty was disclosed in relation to the situation that A found herself in. And to that extent, my lady's question is perhaps answered in this way, that it has always been unclear when a failure to comply with that duty amounts to misconduct. And in seeking to develop that point, the first ground of appeal, A's first ground of appeal, encompasses the first two issues which the parties jointly advance for the court to determine in the statement of facts and issues. That is at paragraph 54 of the statement of facts and issues at MS 54.
Yeah.
Yes, but the 54A, as worded, focuses on the point that my lady is emphasising. We have to decide, first of all, whether there was a duty of disclosure, the failure to do which would amount to misconduct.
Yes. Yes, my Lord. The second issue, issue B, goes to the question, if a duty exists, then was there sufficient evidence within the test propounded in the virtual case and subsequently refined to entitle the employment tribunal to conclude that A's dismissal fell within the range of reasonable responses? And if I may proceed in relation to issue A, at the time of A's suspension and subsequent disciplinary proceedings, she was the head teacher of a maintained primary school, the governing body of which was C. She had been recruited to the role of head teacher at the school in a process which had commenced on the 1st of January 2009. A formal offer of employment was made to her on the 15th of May 2009. That document, which I don't intend to take you to, but for completeness, is at MS 316. Was comprised in a written letter, and A's employment at the school commenced on the 1st of September 2009.
Mr. Palmer, we've been concentrating upon her contract of employment, which presumably begins round about 1st September 2009. But I note from the chronology, which we've got at MS 56, that the arrest and bailing of the man was on the 25th of February, some 25 days after your client had applied to become head teacher at the school. And although he hadn't been convicted until later, it may or may not be, I don't know whether there was any evidence about this, have been pretty obvious to your client when he was arrested and bailed that he would be convicted. At all events, he'd been arrested and bailed when she was applying. Is this right, Mr. Palmer? To be the head teacher?
My Lord, it is.
And so do we also have to look at whether in the course of her application she was under a duty to disclose?
My Lord is correct in relation to the chronology. The arrest took place on the 25th of February 2009. Again, for completeness, that is recorded at paragraph 4.5 of the Employment Tribunal's judgment, which is at MS 162. The appellant had submitted her application form on the 31st of January. That is recorded by the Employment Tribunal in its findings of fact at paragraph 4.1. My Lord, IS, who is the person convicted of making indecent images of children, was subsequently convicted at Birmingham Magistrates Court on the 1st of February 2010, and that is recorded by the Employment Tribunal at 4.6.
Yes, Mr. Palmer. I mean, to be fair, of course, we can see all this from the chronology. I was simply querying whether we may have to look wider than the contract. We may have to consider the position in the early part of 2009 and what your client's duties were then, when she was presenting herself to a panel as being an appropriate candidate to become headmistress.
Well,
My Lord, I think the focus in terms of the prior proceedings in this matter have focused on the period after 1st of September,
And if she
when
wa-
she has been...
if she wasn't under a duty after appointment, could she become under that? Could she be? Could her? No one has suggested, have they, that her dismissal was justified by reason of something not mentioned in her application?
That, my Lord, forms no part of the Employment Tribunal's judgment.
Or indeed of the employers.
Yes,
No.
that's
No,
the critical point.
And the critical point is what the employer thought it was doing.
Indeed.
So I don't think, despite the interesting facts,
Interesting.
we are concerned with her conduct while in employment.
My Lady.
Well, that's very polite of Lady Hale.
It may, my Lord, be the case that it is argued against me that the duty is so expansive that it does extend to...
Well, Mr. Palmer, forget my point for the time being, and we'll focus on the contract.
I'm grateful, my Lord. Turning to the Employment Tribunal's findings, the Employment Tribunal judgment starts at page MS 159. Paragraph 4.1 of the Employment Tribunal's judgment points to the fact that A had had 23 years of successful primary school teaching and management experience and had not been the subject of any form of investigation or disciplinary action during the course of her prior employment. This court will be aware that during the course of the Court of Appeal, particular statutes and regulations were put before the court which had not formed part of the discussions by the disciplinary panel or the Employment Tribunal or subsequently the Employment Appeal Tribunal. I will come to those in the course of my submissions, but as a starting point, A does not dispute that Section 175 of the Education Act 2002 placed at subsection 2 of that section the governing body under a statutory obligation to make arrangements for ensuring functions relating to the conduct of the school are exercised with a view to safeguarding and promoting the welfare of children who are pupils at the school. That particular section can be found in Authorities Volume 3 at MS 383 to 384.
I think it's Authorities Volume 1.
My apologies, yes.
This is the educational equivalent of the section in the Children Act 2004, which places the same duty on a range of public bodies.
My lady, yes.
And would you accept that that provision is part of the factual matrix in which the contract of employment has to be considered?
My lord, yes. And it is plain that issues as to safeguarding were in the mind of the disciplinary panel and subsequently formed part of the findings of the Employment Tribunal as to the concern as to potential enhanced risk to safeguarding. It's also, and there is no demur from this point accepted, that the job description for A, the relevant segment of which can be found in the separate Appendix 2 volume at MS 330.
Can you give, my Appendix 2 doesn't have MS numbers. Can you give the hard copy number as well at the bottom of the page?
My Lord, yes. The hard copy number is 212.
Thank you very much.
And sorry, I was writing something else down. What's the MS?
My Lady, MS 330 and hard copy 212.
Thank you.
Thank you.
What are we looking at now?
My Lord,
Job description.
this is the job description.
Is it 6B?
It is 6B, my Lord, yes. Which is to advise, advise, assist and inform the governing body in the fulfilment of its responsibilities.
Yeah.
That includes their responsibilities under Section 175.
My Lord, yes.
So this is a job description for head teachers in which category then, Mr. Palmer?
This is the job description provided by the local authority B for head teachers, and it is presumed that this is applicable to head teachers of maintained schools.
Thank you.
This segment of the job description has a singular importance because it featured in the Employment Tribunal's judgment as the element informing in the Employment Tribunal's findings, A's responsibilities to C. And returning briefly to a point that I passed over a couple of minutes ago, the disciplinary panel itself did not refer to any specific guidance, although it is accepted that the document which is to be inserted at tab 46 of the volume 3, Safeguarding Children and Safer Recruitment in Education, which came into force on the 1st of January, would have been the relevant guidance.
So what's the relevant bit in the 2007 guidance?
My Lord, my learned friend, Ms. Hannett, will take this court, I think, to two relevant paragraphs. The first being paragraph 2.19, which is on page 4, adopting the numbering in the bottom left-hand corner.
Page 14.
Page 14, my Lord.
14.
And that sets out the obligations falling on the governing bodies of maintained and non-maintained special schools in relation to safeguarding.
Yes.
And separately, my learned friend, I understand, will take the court to paragraph 2.27, which is on the very last page, page 19.
Just as we're here, it's also paragraphs 1.1 and 1.2, and that will save me that journey in due course.
Who's this aimed at? Presumably teachers and governors, is it?
It's aimed at all local authorities, schools and further education colleges.
Yes, seen that. I just wondered who actually got it.
I think, in answer to my Lord's question, 1.1, which my learned friend refers to on page 3 essentially says everyone in the education service shares an objective to help keep children and young people safe by contributing, and therefore it's presumed, as my Lady Hale has just mentioned, that the purpose of the guidance is all-encompassing. At 1.3, it does refer to helping local
1.3 is
authorities
helpful.
and so on.
Yep.
Just returning very briefly to paragraph 2.27, that sets out obligations falling on head teachers of schools and principals of further education colleges in relation to ensuring that policies and procedures are adopted, which have been adopted by governing bodies, are implemented, that sufficient resources and time are allocated to ensure that the objectives of those policies are reached, and that there is an adequate reporting procedure for staff and volunteers.
Yeah. The answer to my question is 1.5, if it matters.
My Lord, yes, that
Certainly aimed at head teachers.
Yeah.
and certainly catches a very large audience at the same time.
Right.
What the guidance doesn't do in any prescriptive fashion is to explore the way in which reporting requirements, which may fall within a duty to disclose potential risk to safeguarding should be applied. And indeed, there isn't in our submission, in any of the relevant documents, an articulation of the duty to disclose how that duty is formed when it is engaged outside the most obvious of circumstances. A does accept in relation to how the process which commenced in relation to the disciplinary proceedings that she was subject to arose in circumstances where there was initially wrong information provided by the Children's Services Department of a neighbouring local authority that A, lived with her partner, IS, who had been convicted in January 2010 for making indecent images of children and was a registered sex offender. That is the Employment Tribunal's finding of fact at paragraph 4.7, which can be found at MS 162. And that was a disclosure made by a neighbouring Children's Services Department to the local authority designated officer, or the LADO, Ms. McKinley of B.
Yes, the error was residing with. That's, yeah.
My Lord, yes. When I say wrongly informed, the element of the information that was wrong was the notion of residing in the sense one presumes, as it was apprehended, a permanent residence.
Yes.
Well, resided with her partner.
Yes, it's residing in partner.
Yes.
I mean, that conveys a very different impression from the facts as found by the Employment Tribunal as to what the nature of the association or relationship was.
My lady, yes.
Yeah.
So materially, there is no guidance which purports to explain the duty of disclosure, and in particular, the issue which is foretold within Lord Justice Floyd's paragraph 69 as to what happens in those circumstances where the level of proximity in terms of relationship between teacher and offender may be slightly more drawn out or distant than circumstances where the paradigm example, where the obligation is obvious and there should be no question as to when the duty arises. And again, it is fully accepted on this side of the room that the first example is obvious, and there is no question as to why the duty would not arise where there is that actual knowledge of enhanced or actual risk. My Lord Justice Floyd, in exploring this example further, and the paragraph which I have referred to, paragraph 69, is at MS 136, goes on in paragraph 70 to look at what he describes as the other end of the factual spectrum. And I think this factual spectrum was the result of submissions made by the parties during the course of the hearing before the Court of Appeal, and in particular a submission point made on behalf of the appellant, which arose from the oral permission hearing before Dame Janet Smith, who raised this point, which was put by way of example as to the uncertainty which revolves around the duty in circumstances that if one is a teacher who has a brother who lives many hundreds of miles away and with whom there is contact twice a year, who is convicted of the same offences that IS was, where does the obvious requirement lie for that person to make relevant disclosure as to her brother's offending?
It's a distant relative is the example used rather than brother, but yeah. But
my Lord,
the
yes,
point is the same.
I think the in making that submission, I was seeking to explain perhaps where this part of the discussion emerged from, and in particular, my Lord's point here, we say is perfectly reasonable, as it explains the inherent difficulties in terms of how this duty, as defined in terms that it was obvious and certain, operates in practice. Lord Justice Floyd went on to seek to explain how this conundrum might be answered, and that lies at the top of MS 137 in the continuation of paragraph 70, and my Lord's final paragraph, in which he says, "It all depends on the detail of the facts known to the teacher and whether a reasonable person with knowledge of those facts would consider that those facts presented an enhanced risk to children."
You agree with that, do you?
My Lord, yes. And my Lord, this position has, of course, always been that position, the position adopted by A, both in relation to the disciplinary panel and subsequently in her defence at the employment tribunal proceeding, that it was an exercise of personal judgment based upon the facts that were known to her, both in relation to MS's offence, but also more generally whether or not that gave rise, in terms of a judgment on the part of A, to make a relevant disclosure.
But I mean, what the test says, well, what a reasonable person with the knowledge would make of it all. Surely that's precisely the sort of question which the tribunal is there to form a view on if there's a dispute.
My Lord, yes. Where we say that the tribunal's application of that examination has fallen short is that it has not, the tribunal did not ascertain that there was any risk or enhanced potential risk to the children at the C school arising out of the nature of the relationship between A and IS. And in a sense, an attempt is made to answer that question by my Lady Justice Black, as she then was in this particular court constitution, in which she suggests that the potential risk is the potential risk because it is a potential risk to the safeguarding of children. We say that the duty, in terms of its whether or not it's engaged, falls more squarely within the approach taken by Lord Justice Floyd in terms of a fact-based assessment.
I think Lady Black was a bit more specific than that. I think it's paragraph 62, isn't it, Mr. Palmer? Second line, Ms. Hannett did suggest examples of the ways in which risk to children may be enhanced by a head teacher living in the same household as an offender, namely because it would afford the offender greater access to the premises or give him access to information about children brought home by the head teacher. And then 3 lines up from the bottom of that paragraph, Lady Black accepts the validity of Ms. Hannett's examples.
My Lord, Lady Justice Black does find on that basis, but she finds on the basis of what were hypotheses advanced by my learned friend, rather than matters which were the subject of findings of fact by the tribunal as to how the disciplinary panel approached their determination as to whether or not there had been misconduct. It was not said by the disciplinary panel that for those reasons which are hypothecated by Ms. Hannett, that there was an enhanced potential risk. Simply, there was an enhanced potential risk, and by reason of not making disclosure, there had been misconduct. I should also add that as well as not making disclosure, it was also what was, I think, characterised by the Employment Tribunal as the failure to recant the position that she had taken, that she wasn't under a duty within A's own assessment to make relevant disclosure.
Yes, the Employment Tribunal at paragraph 26 said that it was obvious that for a head teacher to have failed to disclose such information, that is the conviction, was a matter of misconduct. But built into that, presumably, is that it was obvious that because of her friendship and the particular characteristics of her friendship, that such things as Lady Justice Black referred to in paragraph 62 were obvious, namely that she might invite her friend onto the school premises, or she might take work to their jointly owned house on the odd occasion when she stayed there, giving access potentially to a sex offender to material concerning the children.
My Lord, I can see that that is how the concept of the obviousness behind the duty has sought to be explained at a later stage, and in particular, my Lord may have noted in the Employment Appeal Tribunal's approach, and as commented on by Lord Justice Elias, that there is a return essentially to looking for evidence to suggest why it is obvious. But what the disciplinary panel never did was to put forward the same grounds that were highlighted by my learned friend before the Court of Appeal as to where the risk may be enhanced. I fully accept, my lord, that those might, from the perspective of child protection, be points which could be raised in relation to certain circumstances. But the facts affecting A were not explored as to whether or not those potential areas might have arisen in relation to the nature of the relationship between A and IS. The nature of the relationship was defined by the Employment Tribunal in relatively basic terms. Summarised by Lord Justice Elias at paragraph 6 of his judgment, which is starts at MS 119, in which it is the aspects of the relationship as they were found by the Employment Tribunal were summarised there, and further by Lord Justice Floyd at paragraph 73, which in turn is at MS 137, in which Lord Justice Floyd effectively replicates what Lord Justice Elias had said at paragraph 6. There had, by way of general background, been a concession made by B and C at a case management discussion on the 29th of November 2011, which can be found in the core volume at pages 179, beginning at 179, and 180, at paragraph 2.1 on 180, the respondents are set, at that case management hearing conceded that A had a friendship with IS, not suggested friendship was of a romantic or sexual nature, or the nature, there's a small typographical error there, the nature of the friendship was in any way, and the second typographical error, improper. And it goes on to explain those matters which are subsequently replicated in findings by the Employment Tribunal as to those aspects where there is a sufficiently close friendship between A and IS.
And do we get from the end of 2.1, the case which was then being made by the school, that if she'd disclosed these facts, the association, steps could have been taken to ensure that the association didn't give rise to any danger to safeguarding? And that's what Mr. Griffith, and first of all, that's their case, is it?
My lord, yes.
And it's also what the chairman of the disciplinary hearing seems to have been saying in his evidence at the Employment Tribunal about his approach, which was even then, if only she'd felt able to cooperate in making some plans for how to manage things, dismissal probably wouldn't have been necessary.
I think, my lord, the reference to the dismissing officer or the chairman of the disciplinary panel was Mr. Griffin.
That's right.
What is pointed to in the Employment Tribunal's findings in that respect, and
I'm thinking of 4.26.
Indeed, my lord, I'm grateful for that indication.
Particularly the last half dozen lines.
In our submission, the The basis of that finding is that in the opinion of the disciplinary panel, there had been a breach of what had been described as the particular duty by the employment tribunal, but that was amplified by the failure of A to accept what was deemed to be an error. I think that's been referred to elsewhere as the failure to recant.
Yes, I see.
Returning to the issue of the hypotheses advanced in the Court of Appeal in relation to reasons why the duty to disclose may have been obvious, and Lady Black's apprehension of those, we say a problem with that is that the disciplinary panel and also the employment tribunal had, whilst they had seen that there was a close personal relationship, they hadn't attributed the relationship to be one of cohabitation as commonly understood. And I think that is probably emphasised in paragraph 4.9 of the employment tribunal's judgment at MS 163, which sets out, again, those matters which were traversed by Lord Justice Elias at paragraph 6 of the Court of Appeal judgment.
Yeah.
What is absent, of course, from the employment tribunal's judgment, as well as the evidence of the disciplinary panel, is any findings which are suggestive that IS himself or IS known to A played any part in the life of the school. And certainly there is no allusion in terms of the evidence of the claimant or the respondent before the employment tribunal proceedings that IS did have any part to play in the life of the school. And it's fully accepted, again, perhaps adopting some of the effects of those hypotheses advanced by my learned friend before the Court of Appeal, that returning to Lord Justice Floyd's example, if IS had been participating as for example, as a companion to A in school events, then more obviously there may have been a requirement upon her to disclose the nature of his offending, because those facts known to A would have provided the basis for a more certain perspective as to how a potential enhanced risk may have arisen. And I think answering perhaps in a slightly deferred way my Lord Hughes's question, the disciplinary officer, Mr. Griffin, is recorded as having given evidence, and that evidence being accepted by the employment tribunal at paragraph 4.24, which is at MS 168. The end of that paragraph, we accept Mr. Griffin's evidence that he specifically discounted any matters relating to the concept of grooming from his deliberations. It had no relevance whatsoever as far as he was concerned. Now, I accept that perhaps grooming falls elsewhere within Lady Justice Black's assessment of the obligation to disclose. But certainly the employment tribunal's findings are not ones which can be said to be consistent with IS influencing A at any point.
Are we talking there about the grooming of your client?
Yeah.
Mr. Palmer?
My Lord, yes, the grooming of A by IS
Yes, thank you.
with the
And that's picked up, isn't it, although in a slightly different, different stage of the reasoning, by Lord Justice Elias at his paragraph 48.
my Lord, yes, and I think also
When he's discussing the disqualification regulations, he speculates that the reason why people who live in the same household as a disqualified person might themselves be disqualified was, as he put it at the end, presumably the fear that they may fall under the influence of such persons. But does he deal anywhere with the quite different sort of risk that Lady Black enunciates, which is that the, as it were, primary disqualified person, the offender, may have increased scope for access to the children?
my Lord, at paragraph 50, below 48 on MS 131, again, dealing with the issue as to the childcare disqualification regulations and disqualification by reference to living in the same home as someone who has convictions for either violent offences or sex offences against children. Lord Justice Elias questions the points made by the respondents.
Absolutely, he disposes of the grooming on the basis of Mr. Griffin's evidence. But what I was asking was whether he'd anywhere dealt with the quite different kind of potential for risk, not through influencing A, but through access to the children.
My Lord may have read in this context paragraph 41, which starts at MS 129.
Thank you.
This paragraph initially deals with the contact between A and third parties and advice that she received.
Yes.
And so on. Over the page...
This is reputational damage, isn't it?
It is.
Yep.
He goes on to say that those, again, those hypothetical, separate hypothetical grounds do not provide reasonable grounds to sustain what the tribunal found to be the reason for dismissal. And I think more generally, he makes the point that there is simply no evidence identified by the employment tribunal. This is at paragraph 45, again MS 130, in which he says, in my judgment, therefore, on the basis of the evidence identified by the ET, I do not believe the ET was entitled to find a reasonable employer could properly have concluded there was potential for enhanced risk. I think what he doesn't do, my Lord, in answer to your question, is to go through the list of potential matters in the same way as they are considered by Lady Justice Black and comment beyond the fact that he makes the more general point as there is no evidence in that regard.
Thank you.
If I can turn now to the effect of contact between A and third parties and the advice that she received, the position, as we've just seen in relation to Lord Justice Elias's approach to this, is that whilst, and this is paragraph, returning my apologies to paragraph 41 at MS 129, that whilst the tribunal was entitled to conclude that A, from the evidence before it, that A ought to have appreciated from her various conversations, and perhaps did appreciate that whatever the strict legal position, it would be prudent to tell the governors about the relationship. But that advice cannot ultimately determine whether she was under a duty to do so. that point is drawn in conclusion to Lord Justice Elias's rejection as to whether or not inferences can be drawn from the fact that A had taken soundings of third parties to determine whether or not she was under a duty to disclose. The more general point we say that arises from that is that there were not, in relation to those soundings, any parameters of particular duties drawn. We say the correct analysis of those soundings, if I can use the term again, is expressed by Lord Justice Elias in this part of his judgment, in which he points to the fact that they are matters which might give someone a cause to think whether or not it is prudent to do so, but they don't actually define the parameters of any particular duty. And by way of reminder, those soundings were on a limited basis to persons to whom A was known, namely a police officer and a probation officer associated with IS and the anonymised contact that was made with probation officers, various charities, governors, associations, and so on. So, in terms of an overarching submission, we say that the Employment Tribunal simply didn't, in their findings of fact, based upon its analysis of the disciplinary panel's actions, identify any evidence in which a safeguarding issue had arisen beyond the potential, but not the potential of enhanced risk. And in short, there was no evidence that there was an enhanced potential risk to the children at School C. And therefore, in answer to the question as to whether or not A's actions constituted misconduct, we say, and this has been A's position since the Employment Tribunal, that her decision not to inform C was an act of personal judgment, and it was an act of personal judgment which may be taken based upon the facts which are applicable by a reasonable person in A's position. I'm conscious of the passage of time, and therefore, if I can move to those legislative provisions and regulations which are put before the court and return to the references to the childcare disqualification regulations 2009, which are said to be illustrative as to how relationships between teachers and managers of schools are now prefigured in legislative terms. These are, of course, variously discussed in the judgments of Lady Black and Lord Justice Elias. They're described, I think, in passing by Lord Justice Floyd at paragraph 74 as being a straw in the wind, but the factual situation here is not one encompassed by it. And we say that the limitations of those legislative provisions in terms of assisting this court in reaching its determinations are essentially shaped by that fact, that whilst they may quite accurately prefigure childcare arrangements now, and the court will have noted that many of those regulations post-date the events in question, or are specific in the case of the childcare disqualification regulations to matters relating to early years and later years education and the disqualification of relevant persons. One presumes that certainly the approach taken in the guidance has evolved over time and has been reflective of recent issues surrounding safeguarding. That they were not, of course, in any respect put before the Employment Tribunal or the Employment Appeal Tribunal. They were not mentioned in the respondents' evidence at the Employment Tribunal, and they form no part of the Employment Tribunal's finding of fact. We've seen at paragraph 50 my Lord Justice Elias's approach to the issue as to the relevance of those documents, and for those reasons, as well as the more general reasons, we invite the court to conclude that in the factual circumstances of this case, there was no duty on the evidence before the panel, which is the disciplinary panel of the Employment Tribunal, which is in any way assisted by those particular provisions. For the reasons that I have outlined in my submissions and in response to questions from my lady and my lords, we invite the court to conclude that in the factual circumstances of the case, as recorded within the findings of fact by the Employment Tribunal, that no duty to disclose was engaged on the part of A to make disclosure in relation to the nature of her relationship with IS. As such, we say there was no substantive basis for the disciplinary panel to assume that that A had, by deciding not to disclose information relating to the nature of her relationship with A, had committed misconduct. And nor do we say that in light of that position, that the failure to recant can be said to amplify or distort her conduct into misconduct. It was a position that A took, having formed a judgment on the facts before her. And certainly those facts did not in any way betray the serious misconduct which the panel sought to justify her summary dismissal with.
Seems to me, Mr. Palmer, that this business about, oh, well, she didn't recant, that really can't be relevant to whether there was misconduct. It can only be relevant to whether dismissal was an appropriate disposal, granted that there was misconduct.
My Lord, we accept that.
Well, do you now want to move on to
Issue
issue
B,
B?
my lady. I think I can move through the remaining issues in good time.
Well, you've been very generous to yourself, or in fact, you've been very generous to Miss Hannon, because in our experience, the appellant always takes longer than the respondent does. And you've allowed her to take longer than you.
My lady...
That's not necessarily a criticism.
You've
Probably a criticism of her.
You've opted to put it into reply. That's what you've done. Let's press on.
In terms of the second issue, whether or not dismissal fell within the range of reasonable responses, we say that the approach adopted by Lord Justice Elias here is to be preferred over that of Lady Black and Lord Justice Floyd. And we say that for this reason, that absent any misconduct arising from the duty to disclose and my Lord Justice Elias's analysis as to there being an absence of any evidence before the tribunal which supports the issue, which supports the basis for dismissal, then any dismissal by its very nature falls outside the range of reasonable responses. I don't think my learned friends and I are in any disagreement as to the appropriate law in relation to the test of the range of reasonable responses. But we do say here, in terms of whether or not the dismissal fell within that range, that in order for the dismissal to be permissible, the panel needed more than simply the sense that the duty was engaged in order to establish a reasonable suspicion amounting to belief in guilt, as is required within the second limb of the Birchall test.
But that's the guilt point, isn't it? And if there was a duty to disclose, which we've just been discussing, there isn't any question about that. She didn't disclose. No, that's perfectly straightforward. It's the third limb as to whether, in the circumstances, that being misconduct, which she had committed, whether in the circumstances dismissal was a reasonable response. Well, that's not the question, whether within the bounds of things that a reasonable employer could do in the circumstances. But there can be no doubt that if it was misconduct not to disclose, she didn't disclose.
I think that
most of the Birchall thing is about was the employer reasonable in concluding that the misconduct, which clearly was misconduct, such as a theft, had been committed.
It was done.
That doesn't arise in this case.
my lady, we do. I defer to Lord Justice Elias's position here as to the absence of evidence which might engage the...
But he's talking about whether there was a duty to disclose.
But beneath that duty, my lady, there is also the question as to whether or not there was any matter of enhanced potential risk.
Yes, that's the point he takes, yes. That's right.
Yes, but doesn't that relate to the prior question of whether there's misconduct?
Yeah.
Once we get into Birchall, we're looking to whether the employer believed that there was misconduct, whether the employer had, in his or her mind, reasonable grounds to sustain the belief. And then the third question about investigation behind that. Giving rise to the what I think is casually described as the range of reasonable responses. I mean, clearly, if you win on Lord Justice Elias's approach that there wasn't misconduct, we don't get here.
No.
Yeah.
My lord, yes.
And if you lose on that point, we don't get that either.
Yes.
Yes.
But you can certainly argue that even if it was misconduct, in the light of the circumstances as known to the employer, it was not within the range of reasonable responses to dismiss her as a result. You can certainly argue that, which is what I understood issue B was supposed to be.
Yes.
My lady, yes. And again, with one eye on time, in a nutshell, that is the position, in that in terms of the action that is taken by adopting dismissal as the sanction, that simply that is falls outside the range of reasonable responses.
What do you say they should have done? Assuming, which I appreciate you dispute, but just assuming for the moment that there was a duty to disclose, which she broke, what should they have done?
My Lord, it's probably a trite answer, but sanction less than dismissal insofar as no harm had been occasioned.
So it's what, advice as to conduct?
Written warning, advice as to conduct.
Yeah, thank you.
My Lady, if I can pass from that issue B to issue C, we say that an Article 8 right does arise in this case, and we say in relation to the facts that dismissal was a disproportionate response in light of the connection of matters with A's private life and her rights in relation to that. My Lady, we do concede, as we did in the EAT and in the Court of Appeal, that this, we don't challenge the range of reasonable responses as being, test as being out with Article 8, and inevitably, to an extent, this ground stands and falls by reference to issues to be determined in connection with fairness.
I mean, you could, in fact, had you wanted to, but you haven't done, so we're not going to consider it, have challenged the whole idea that proportionality under Article 8 is the same as the range of reasonable responses test under unfair dismissal. You could have challenged all of that, because at least in terms of who makes the decision, there could be differences. Because there's a very clear authority that, as the court has got, is a public authority and therefore has a duty to respect and not act incompatibly with people's human rights. It's for the court to decide, or in this case, the tribunal to decide on proportionality, and not whether the employer's actions were within the range of reasonable responses, which is a different test. But you've not argued that. You're not going to argue that.
It's not argued, my lady. No.
You probably think it's unarguable, and so that's why you didn't try and do it.
My lady, that takes me...
that means we go no further. C takes us no further than B, really.
No, my lady, no, that's correct. My lady, my submissions in relation to D, in terms of the reduction of compensation, I think can be dealt with shortly. These two provisions are entirely subservient upon this court's findings in relation to effectively A and B. If it is found to be a substantively unfair dismissal, then the question of Polkey falls away, and in relation to culpability arising in relation to A's contributory fault or otherwise, that also is a matter which will require further consideration as to whether or not it is applicable.
Yes, you need to be a reassessment based on the hypothesis that you succeed in A and B. One would need a complete reassessment of that issue in the light of the changed circumstances.
My Lord, yes, in relation to contributory fault.
Yes.
My lady, unless I can assist yourself or my lords further, those are my submissions.
Well, you've withstood our onslaught with commendable fortitude, so thank you very much indeed, Mr. Palmer. I think that's all the questions we wanted to fire at you. Yes,
From a lady.
yes, Miss Hannett.
My Lady, my Lords, in respect to the 4 issues arising on the appeal, the respondent's position is as follows in summary. In respect of issue 1, we say it was obvious that the appellant ought to have disclosed her relationship with IS to the governing body, but in any event, that conclusion was not beyond the range of reasonable responses open to the respondents. The fact of his conviction means that IS poses a risk to children in general, and it follows that disclosure was necessary to enable the governing body to assess the risk, if any, posed by IS to the specific children in this school, and to put in place relevant measures to mitigate any such risk. My Lady, under issue 1, I will also deal with the question that you posed to my learned friend, namely who decides whether or not it is misconduct, and the respondent's answer to that question is that is a question for the employer, and that is subject only to the requirement of reasonableness. The second issue, the non-disclosure, coupled with the appellant's subsequent failure to accept that she ought to have disclosed, meant that the Employment Tribunal was right to conclude that dismissal was within the range of reasonable responses open to the respondents. I don't understand my learned friend to have seriously asserted to the contrary. And finally, in respect of issue 3, as I think is now agreed, if Article 8 of the Convention was engaged, the decision to dismiss was proportionate. There isn't any point now being made that Section 98 of the Employment Rights Act and the range of reasonable responses test falls out with or doesn't comply with Article 8 of the Convention.
It's not been contested if you win on issues 1 and 2 that Article 8 will add anything else.
No, my Lord, quite. Yes. It isn't going to add or detract anything from the matters that are raised on this appeal. Finally, in respect of issues 4, the parties agree that the matters raised, namely the POG deduction and contributory fault, stand or fall on the success of issues 1, 2 and 3. So, my Lady, I propose, I think, to deal with issues 1 and 2 largely together. I was going to turn to deal with issue 3, but perhaps there won't be very much that I need to say in that respect, in light of what my learned friend had said. In respect of issues 1 and 2, we set out 5 propositions in paragraph 98 of our written case, that's at MS 97 to 98, and I propose to organise my submissions on issues 1 and 2 in that order. My Lady, it is important to identify at the outset the parameters of the dispute as between the parties. The dispute is a narrow one, and subject to my Lady's point put in the question this morning, is essentially one of fact. The parties agree...
Well, if we'd thought it was only a question of fact, well, you would not...
No, well,
we would not be here.
My Lady, quite. I appreciate that. The parties agree that the head teacher of a school has a duty in principle to disclose to the governing body any matter that might reasonably be thought to inhibit their ability to carry out their safeguarding functions. And similarly, all of the judges below in the Court of Appeal agreed on that point. I don't think I need to turn it up. I think it's been well canvassed, but one can see that in the judgment of Lord Justice Floyd at paragraph 69, and also from the judgment of Lord Justice Elias, paragraph 43 and paragraph 45, that's at MS 130. Where Lord Justice Elias deviated from the judgments of Lady Justice Black and Lady Justice Floyd was in concluding that that duty in principle didn't apply to the facts of this case. The judges below were right to reach that conclusion for the following summary reasons. Such a duty is necessary given the respective roles of the governing body and the head teacher. Specifically, the governing body has a duty, a statutory duty, to safeguard children and to promote their welfare and well-being.
That's section 175 that we've looked
And
at
also
already.
section 21, which I will take you to in due course.
Thank you.
The head teacher is, of course, responsible for the day-to-day running of the school and is effectively on the shop floor in the way that the governing body is not. And it's obvious, in my submission, that the governing body cannot fulfil its statutory functions without the head teacher informing it of any matters that might reasonably be thought to inhibit their ability to carry out their safeguarding functions. How otherwise would they know what was taking place in the school? Turning to Lady Hale's question of who decides whether it is misconduct or not, as that is the logical first question, the answer is that it is for the employer. The question is whether it was reasonable for the governing body to conclude that a failure to disclose amounted to misconduct. That is because there is authority to the effect that whether there has been a breach of the employment contract or not isn't determinative of whether a decision to dismiss is reasonable or not.
But that may not be correct.
No, I will explain.
It's not authority at this level, is there?
No. Well, my lady, that there is authority, which I will take you to in a moment, in the case of Gisda, about the divergence between...
Yes, Gisda is not going to help us.
My lady, may I take you to that in a moment? And
You may, but I think
say why that is...
we've looked at it very recently in another context.
Well, may I start with the statutory provisions themselves?
So that would be helpful, yes.
Section 98 is at tab 4, which is first volume, and section 98 is at page MS 387.
Thank you.
The structure of section 98 is that subsection 1, in determining for purposes of this part whether the dismissal of an employee is fair or unfair, it's for the employer to show the reason, or if more than one, the principal reason for the dismissal, and that it is either a reason falling within subsection 2 or some other substantial reason of a kind, such as to justify the dismissal of an employee holding the position which the employee held. A reason in subsection 2 falls within this subsection if, paragraph B, it relates to the conduct of the employee. The way that the section works is that the employer, having satisfied or shown that the reason for the dismissal is one that is presumptively fair, i.e. one of the reasons within subsection 2, the question for the employment tribunal then focuses on subsection 4, where the employer has fulfilled the requirements of subsection 1, the determination of the question whether the dismissal is fair or unfair, having regard to the reasons shown by the employer, depends on whether in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee, and shall be determined in accordance with equity and the substantial merits of the case. So, my lady, in looking at paragraph 4A, the question is whether the employer acted reasonably or unreasonably in treating the reason as a sufficient reason for dismissing the employee. And in my submission, that answers the point. The reasonableness bites on not just whether or not it was reasonable to conclude that the employee committed an act of misconduct, but whether, in fact, it was misconduct in the first place.
So it's not just whether the deed was done, but whether it was wrong. Is that it?
Quite. And my lord, further in support of that, subsection 2 refers to conduct. It doesn't refer to misconduct. In other words, the employer must show, first of all, that it is something potentially capable of amounting to a reason for dismissal. Whether it is or not is determined by the provisions of subsection 4, i.e., whether it was reasonable or not.
And Ms. Hannett, this case has proceeded on the basis that the appellant was in breach of an implied term which cast a duty on her. So the case has proceeded on the basis that the misconduct was a breach of her contract. Are you submitting that that conduct can go wider than breach of the employee's contract?
But I am. Can I take the answer to your question in some stages?
Do.
My Lord, it's quite right that the case has proceeded. I think perhaps it might not be quite correct to say it has proceeded on the basis of a breach of implied term. Certainly that language is not used by the Court of Appeal. And certainly it has always been the respondent's case that there was an implied term to disclose. However, if the respondent was wrong about that, that in itself didn't render the dismissal unreasonable. So, my Lord, I wouldn't perhaps quite, with respect, accept the premise on which the question was put, because I think the case has always been put in the alternative. And indeed, I hope I'm not being disrespectful to the judges below, that no one perhaps has really identified in terms whether or not this is an implied term or not. It has always proceeded in the alternative, and indeed that's precisely how the Employment Tribunal put the case, where it said either by way of the contract or otherwise. So the Employment Tribunal itself also recognised either possibility.
Can you, sorry, I have some more difficulty. Can you just formulate what are the two alternatives then? One is breach of an implied term of the contract. What is the other?
So one is the breach of the implied term of the contract, the implied term being the duty to disclose.
Yes, I understand that, but what's the alternative?
But the alternative is that it was reasonable for the governing body to conclude that the failure to disclose amounted to misconduct.
Even if not a breach of an implied.
Even if not a breach of an implied term.
Are there some pretty clear examples which those who work in the employment tribunals well recognise of what is accepted to be conduct justifying dismissal, which does not involve any breach of contract? Usually, conduct of the kind that hasn't been foreseen well, often I suspect it will be analysed as bringing the organisation into disrepute or something like that. And so it may be analysed in more or less contractual terms. But I'm just wondering whether those of us who don't do that much of this are missing well understood examples of conduct which is not a breach of contract, which is not infrequently encountered as a justifiable basis for dismissal.
You might like to think about that.
My Lord, I was going to say, I think there isn't an obvious example that comes to mind, but I can show you certain examples in the case law, but I think it's fair to say that in the case law, it is often the employee that has asserted that the dismissal is in breach of contract.
Quite. Other way
rather
around.
than the converse.
Yes.
So whilst the examples in the case law demonstrate or make good that point, I think it is fair to say that perhaps there aren't any obvious examples of the converse, but perhaps if I can come back to you
Of course.
to lunch on that point.
I mean, are you saying, is this right, that for the purpose of 1 and 2, subsections 1, all the employer has to do is that the reason related to conduct, whether or not it was a breach of an implied term.
Yes, my Lord, yes.
And so, and then moves on to 4, and the only question there is whether the employer acted reasonably or unreasonably in treating as a sufficient ground for dismissal.
Yes. And of course, it may be that whether there is a breach of contract or not is a relevant matter that goes to reasonableness, But the point is it's not determinative of the question.
Yes, I understand, but there must be something wrong about it in some sense, or inappropriate, or I don't know, whatever word you use.
Well, the limit on the concept is that it must be reasonable for a reasonable employer to have concluded that that is conduct capable of giving rise to a dismissal. So
Yes, but if it wasn't, it wouldn't be acting reasonably.
In terms of the conduct.
But you put all the weight once on the subjective element of 4A, and I can see a sort of literal reading how you get there, but it seems slightly odd. That doesn't have to be some objective test, if not of breach of contract, objective test of inappropriate behaviour or something.
Well, the objective test, my lord, is that applied by the employment tribunal, which is it a matter which a reasonable employer...
That's the range of responses, yes.
Yes, exactly.
I
So that's the objective constraint on the concept.
Well, if you're right, then the answer to my lady's question is clear.
If one looks at
The
2A,
employer decides.
if one looks at 2A, which is capability and qualifications, would there be any breach of contract involved in a 2A case? I suppose there might be sometimes, but would there always be?
Well, my lord, no, not always. No.
Yeah, but there'll be no breach of contract by the employee if he's made redundant. So we're looking peculiarly at
It's really
2B.
only conduct.
It's quite right.
Can the conduct give rise to a potential sanction of dismissal absent some breach of contract? And I'd be very interested to see if there's case law exactly on that point.
Yes, I would too. And of course, related to that is that we're dealing with a case which would be the standard case where the employee is dismissed for misconduct.
Yes.
So again, one's got to ask, well, is that to be judged by what the employer thought was misconduct, or is it to be judged by what was actually misconduct? Because that was the reason given, is misconduct in this case, and
Yes.
in most cases.
Yes, but of course, in this case, of course, it wasn't simply the fact of the failure to disclose that resulted in dismissal. It was always also, of course, that coupled with the inability to understand why that was problematic.
Oh, we know that.
Yes.
We know
Yes,
that.
indeed.
We're talking here about the law.
Yes,
So you wanted to take us to some cases.
yes, I was going to take you to Gizda, if I may.
You may, of course.
Noting the initial objection, I will
No.
nevertheless try to take you to Gizda. It's Authorities Bundle 1 and it's tab 16. It starts at page 633. Melody, the issue arising in the case is set out at paragraph 6, which is on page 636. Namely, when did the termination of her employment take effect? So the claimant in this case was dismissed by a letter.
What was the effective date of termination was the issue, because it's governed by a statutory phrase which talks about the effective date of termination.
Yes.
And this case held that whatever might be the common law as to the effective date of termination of a contract of employment, the effective date of termination for the purposes of the statutory provisions was when the employee got to know about it or had a reasonable opportunity to know about it. Have I got it right? Have I recalled it right?
Yes, Melody, that's quite right.
Yes.
That's exactly right. That's exactly
Well, we have been looking at it in detail quite recently because we've been looking at what the common law is. And I'm keeping a very, very straight face as to what the common law is.
Well, Melody, the analysis is picked up at paragraph 34, which is on page 643. And of the court referred back to previous decisions of the Employment Appeal Tribunal, which had held that employees should have a reasonable opportunity to discover the fact of dismissal. And at paragraph 34, noted that underlying both decisions, in other words, the Employment Appeal Tribunal decisions, although not expressly articulated in either, is the notion it would be unfair for time to begin to run against an employee in relation to his or her unfair dismissal complaint until the employee knows, or at least has a reasonable chance to find out, that he or she has been dismissed. At paragraph 35, Lord Clare noted that these considerations provide the essential rationale for not following the conventional contract law route in the approach to the interpretation of Section 97. As Lord Justice Mummery said, it's a statutory construct. It is designed to hold the balance between employer and employee, but it does not require, and nor should it, that both sides are placed on an equal footing. Employees as a class are in a more vulnerable position than employers, and protection of employees' rights has been the theme of legislation in this field for many years. The need for protection and safeguarding of employees' rights provides the overarching backdrop to the proper construction of Section 97. The analysis, I think we can skip over paragraph 36, because the analysis then picked up at paragraph 37. We do not consider, therefore, that what has been described as the general law of contract should provide a preliminary guide to the proper interpretation of Section 97 of the 1996 Act, much less that it should be determinative of that issue. With the proposition that one should be aware of what conventional contractual principles would dictate, we have no quarrel, but we tend to doubt that the contractual analysis should be regarded as a starting point in the debate, certainly if by that it is meant the analysis should hold sway unless displaced by other factors. Section 97 should be interpreted in its setting. It is part of a charter protecting employees' rights. An interpretation that promotes those rights as opposed to one which is consonant with traditional contract law principles is to be preferred. Paragraph 38, he rejects the thesis that the cases set out therein represent a general acceptance that statutory rights given to employees should be interpreted in a way that is compatible with common law contractual principles, if indeed they are as they have been represented to be. And he goes on to say, following sentence, of course, where the protection of employees' statutory rights exactly coincides with common law principles, the latter may well provide an insight into how the former may be interpreted and applied. That is a far cry from saying that the principles of contract law should dictate the scope of employees' statutory rights. In paragraph 39.
What are we hoping, what are we looking for in this?
Well, my Lord, I'm so sorry. The point is that there is a distinction between the provisions of the Employment Rights Act on the one hand, in that they set out a statutory regime protecting the rights of employees.
We know that, yes.
But so far, it has been in the context that the statutory regime gives protection to the employee.
Yes.
Therefore, an employer can't say, well, I'm contractually, can't say, I can't be acting unfairly because my contract lets me do this. Non-constat, that an employer, this regime entitles an employer to say, well, I have no contractual right to dismiss you, but I'm going to do it. So I'm quite keen to see how this case allows an employer to hold something as a misconduct when it's not a breach of contract.
Well, and you've very fairly, of course, read these passages to us, and the reason given for construing the statute more favourably to the employee than possibly the common law is, that's an open question, at the moment, is that the statute was designed to give employees better rights than the common law. You are praying this in aid in order to suggest that the statute is giving the employer better rights than the common law.
Yeah,
No,
precisely.
my lady,
That was your point, I think, my lord, isn't it? But
It was exactly.
my lady, that's not so. Rather, it's to make the point that when one has a statutory regime, as in the 1996 Act, the starting point for the interpretation of the provisions of that regime doesn't come from contract law. So in other words, one simply doesn't import the law of contract into the Employment Rights Act 1996. And that works both ways, my lady.
But one starts in the
One way
assumption
and not
that
the other.
one starts in the assumption that it's not taking away contractual rights the employee has.
So, my lord, we're not talking about a situation in which, here, as the case law makes clear, where there is a term of the terms of the contract may well be very relevant to the question of reasonableness. And I'll take my lady and my lords to a case in a moment makes good that point. But it isn't determinative, and that's the critical distinction. Relevant but not determinative. Can I maybe take you to the next case which makes good that point?
Well, the paragraph 39, before we leave this case, makes it clear that one has to segregate common law principles relating to contract law from statutorily conferred rights. The implication seems to be that the statute is giving the employee more. Is there anything in this case of Gisda which suggests that the employer can invoke the separation for his or her benefit?
No, but Manuel, that's not the proposition that I'm seeking to rely on. I'm not seeking to suggest that it's for the benefit. What I'm saying is that intellectually one has to distinguish the Employment Rights Act on the one hand and common law principles of contract on the other. And the whole point is that one doesn't import contractual principles into the Employment Rights Act. They may be relevant, but they're not determinative. My lady, my lords, the next case that makes that point in my submission is the case of Shevlin, which is in the second bundle of authorities. At 32. At the starting page is MS 1069. Melody, this is a decision of the Employment Appeal Tribunal. And the issue, I think, can be taken from the summary at page 1071, or the relevant facts, is that the claimant was dismissed by reason of redundancy, and in concluding that dismissal was fair, the Employment Tribunal didn't consider the alleged by the claimant breach of contract on the parts of the respondent was relevant, but even if there had been such a breach on which the Employment Tribunal made no finding, the dismissal was still fair. On appeal, the claimant argued that the Employment Tribunal had erred in law by failing to make a specific finding as to whether the respondents had acted in breach of contract. And in particular, she contended that she had a contractual right to be employed for the term of Lady Sainsbury's life, that was her employer, plus 6 months. And by dismissing her earlier than this, the respondents had acted in breach of contract, and that was relevant to the fairness of the dismissal. The judge summarised the issue arising on the appeal at paragraph 13, which is MS 1076, whether the Employment Tribunal erred in its approach to the issue of whether the claimant's dismissal was unfair as a result of being in breach of contract. And, my lady, my lords, the judge summarises the previous case law that had arisen in this context, and at paragraph paragraph 33, the judge summarises the effects of those decisions. Halfway through paragraph 33, she concludes, she looks at the case of Hooper, where the reason for the dismissal was capability due to ill health. Mr. Hooper's argument was that the respondent could not lawfully dismiss for that reason, given his contractual entitlement, and that was a relevant factor in determining whether the dismissal was unfair. So in that case, the relevance of the point arose from the fact that the respondent had, on Mr. Hooper's argument, committed itself to retaining employees on sick leave and not dismissing them on medical grounds. It then did precisely that which it said it would not. Even then, it was held that the existence of such a contractual obligation would not be determinative of the question of fairness, albeit that it might be a potentially relevant factor in determining the reasonableness of the employer's decision to dismiss. The link between the contractual obligation and the fairness of the reason for dismissal seems to me to thus arise where it can be said there is a coincidence between the employee's common law contractual right and her statutory right not to be unfairly dismissed. That might be a slight stretch of the language in SIF, the case I've just taken you to, but it seems to reflect the way in which the relevance of contractual rights has been treated in unfair dismissal law. The contractual right has relevance to the fairness of the dismissal when, and because, there is a coincidence in the issues to be determined given the particular reason for the dismissal. Thus, fairness of a dismissal for refusal to obey a reasonable instruction will require consideration as to whether that instruction was reasonable, and that in turn may require determination as to whether the instruction was lawful under the contract, or by analogy with Mr. Hooper's case, where the employer dismissed for a reason relating to capability due to ill health, where it had previously committed not to dismiss in those circumstances. The fairness of the employer's decision might give rise to the question that the employer had previously agreed it would not dismiss employees in precisely the circumstances in which, and by reason of which, it had dismissed that employee. So, my lady, what one takes from that summary of the case law, which my submission is an accurate summary of the case law that had gone before, is that the contractual position is relevant, and particularly relevant where it aligns to be dismissed, but it isn't determinative of the question. In other words, an employer can dismiss an employee even when there has been no breach of the contract by the employee.
It's quite a jump,
Vice
isn't
versa.
it? I mean, this was whether the employers were in breach of contract. You jump very nimbly to what we're concerned with, which is conduct, which led to a dismissal. And it doesn't necessarily follow that from the one to the other.
Is there other case law in addition to this that we should be considering?
Well,
Before you answer that question, which I hope you will answer, could you just help me? She cites a great many cases. Are they all EAT cases?
my lady, there's a case of the Court of Appeal, Hooper, which is...
Hooper is a Court of Appeal case.
That's a Court of Appeal case, my lady, yes. But I think that's right to say that that is the highest, with the exception of the Supreme Court case in Gisler, of course, which
yes,
we have just been to.
Do we have Hooper in the
my lady, I don't think that we do have Hooper, but I can arrange for that to be provided at lunchtime. We don't have Hooper. No, we don't have Hooper.
Well, can I test it on the facts of this case, please? The starting point for misconduct is the existence of a duty to disclose.
Yes.
Yes. Where does that duty? How can that duty arise as between the employee and the employer, other than in contract?
Well, my lord, I want to be quite clear that I, of course, say that there is an implied term in this contract.
Yes.
So that's my starting point.
Yes, and I don't think that is seriously disputed, that there is an implied term of a duty to disclose.
No.
The point that was being taken against you was within the spectrum that these circumstances don't come close enough to Lord Justice Floyd's first example.
But to answer the second limb of my lord's question, I think perhaps the focus of the language is perhaps what obscures the answer to the question, because the question is not, is there a duty to disclose? The question, on my analysis, is whether it was reasonable for the employer to conclude that it was misconduct not to disclose.
Well, you've put it in two ways. You've put, firstly, it was a breach of contract, which makes it automatically misconduct. Or, and then the only question is, was dismissal a reasonable response in the circumstances? Or you say, alternatively, even if it wasn't a breach of contract, the employer, it was within the range of reasonable responses for the employer to say, this is a good reason to dismiss. You put it both ways.
Yes.
It's all right, you won't be the first council who wants to have it both ways. Yeah?
Well, my lady, in fairness, I didn't understand the point to be one in dispute, as in the sense
Well,
that
we're disputing it with you.
No, well, as you may.
I put it to Mr. Martin right at the
But the
outset.
second formulation doesn't depend on finding a, quote, duty of any kind.
No, quite. And I see that the language that has been used below obscures that proposition, because in fact the question isn't whether there's a duty or not under the second formulation. The focus in the second formulation is on the reasonableness of the employer's conclusion that it was misconduct not to disclose.
I must say, I find it quite difficult to see how it can be reasonable to dismiss someone for if there's not some sort of duty of some kind, moral or something.
Well, but in answer to my Lord's question, again, I think perhaps framing it in the language of duty is...
I was just saying it seems to be a consequence of the way you put it.
No.
There must be something done which breaches some duty or some obligation or some standard, which makes it reasonable to treat it as a ground for dismissal.
Well, I think, I mean, again, I can only fall back upon the same way of putting it, which is that the limit on that formulation is the reasonableness of the employer's conclusion that that is misconduct capable of constituting a dismissal.
I think have I understood it right? Your principal point, as I understand it, is that the statutory scheme which is set up by Section 98 is not essentially a contractual scheme at all. The contractual questions arise when there's a common law action for wrongful dismissal. But you say, do you, that they don't arise when there is a statutory claim for unfair dismissal?
That's right, my Lord.
So can a dismissal be fair without being wrongful? In the context of conduct we are now. I mean, clearly in redundancy and capacity it could, but what about conduct?
Yes, it could.
We need to think of some examples, don't we?
Yes, we do. But putting the example to aside for one moment, yes, it could, because, of course, for wrongful dismissal, it would need to be in breach of contract. But in my submission, under unfair dismissal, there isn't that same requirement.
It's simply not about contract, you say. Yeah.
Well, I don't go quite that far, my Lord. I hasten to emphasise, I'm not saying it's completely irrelevant.
Oh, no.
Of course, in many cases, it may be extremely relevant.
Yes, I've got that.
But not determinative.
Yeah.
Well, clearly a dismissal can be unfair without being wrongful. Yes. And clearly a wrongful dismissal can also be, and I would say almost invariably it would be, an unfair dismissal. And the part of the point of the whole introduction of the concept of unfair dismissal was to give somebody wrongfully dismissed more rights to more compensation than they were entitled to at common law. But also probably to broaden the circumstances in which they could claim that they had been, in fact, certainly broaden the circumstances in which they could claim that they had been dismissed in such circumstances to give them a remedy. It was doing both of those things.
Well, there'll be any number of cases where the dismissal is not wrongful but may yet be unfair. All the ones where the dismissal is in accordance with the contractual term for notice, but is yet
Unfair.
Still unfair.
Unfair.
Shouldn't have been done.
So that's clearly possible, and I understand why you say that demonstrates that the system which began with the 1972 Act, was it? Anyway, the system that began all those years ago was not principally about contract. It was about a concept of fairness of dismissal. But I still have trouble with conduct.
Well,
but there we are. You're going to think about that over lunch.
Shall I park the examples that have been requested until after lunch and then perhaps return back to where I sort of dived off my submissions?
And there's at the top of page 1080 in the case we've been looking at, there's a summary of what I think is the point you're making by Mr. Justice Phillips about the difference between unfair dismissal and wrongful dismissal. I'm not sure it meets my Lord Hughes's point about conduct, but it.
Can we find this?
Page 1080.
Thank you.
It's from a case.
Paragraph 22, my lady.
Paragraph 22.
Yes, quite. Well, that's the original distinction. God, I forgot that.
Yeah.
Yes. You said you'll come back to it after lunch, but can you include in your consideration the circumstance that conduct, when it takes the form of an omission, a failure to act, where does the obligation to act arise, other than from the contractual relationship? There may be examples, I don't know, but I would like to probe that.
Quite.
Thank you.
But Ms. Hannett, are you saying, well, Lady Justice Black, in her judgment, talks in terms of obligation, when Lord Justice Floyd, in his judgment, talks in terms of duty, that they are not accepting your first argument, that there was an implied term? Because otherwise, as has just been asked, where does the duty come from? Where does the obligation come from?
My Lord, I say that they are, but in fairness, I have to accept that the language of implied terms and the statute, or the test that one usually applies in determining whether a term has been implied to the contract isn't present in the judgment. That language isn't used. But in my submission, neither do they probe the second proposition that I have advanced. So I can't say with certainty that's what they had in mind, because the language isn't used.
You're worried, as I understand it, that in a case where you say there is a perfectly clear implied term, there is a risk that we might end up scuppering well-understood principles if we venture outside the contract.
Well, indeed. And my Lord, just to be absolutely clear, I don't say that I need that in this case.
No.
I say this is an absolutely paradigm example of an implied term, and I'll explain. I'm going to move on to explain why that is so. That's really the next section of my submissions.
Good.
So, to make good propositions 1 to 3, which really encapsulate the short point that an implied term must be implied into the contract of employment of disclosure. I'm going to start, if I may, by just looking at the relevant provisions of the Education Act 2002. Those are in Volume 1, at tab 3. I'm going to start with section 21, which is on page 375. Subsection 1 makes it clear that, subject to any other statutory provision, the conduct of a maintained school should be under the direction of the school's governing body. Subsection 3 makes provision for regulations to be made, which may, amongst other things, paragraph B, define the respective roles and responsibilities in relation to the conduct of a maintained school, whether generally or with respect to particular matters, of the governing body and the head teacher, and confer functions on governing bodies and head teachers of such schools. And the relevant regulations, which I shall take you to in a moment, are the School Governance Roles, Procedures and Allowances England Regulations 2013, which are at tab 10, or MS 428. Turning back to section 21, subsection 5 requires the governing body of a maintained school, in discharging their functions relating to the conduct of the school, to promote the well-being of pupils at the school. Well-being is defined in subsection 8 in relation to pupils at a school in England as meaning their well-being so far as relating to the matters mentioned in section 10, subsection 2 of the Children Act 2004.
Oh, well, there we are.
Yes, and if you wish, you can keep a finger in there and just turn back to Authorities tab 2, MS 369, section 10, subsection 2, sets out what the content of well-being is, and that includes, at paragraph B, protection from harm and neglect.
It's a bit of a statement of the obvious, isn't it? I mean, if that's not what a school is doing.
Yes, well, my Lord, quite.
Anyway, there we are. There it is.
Well, but my Lord, that does
That's
feed
what the
back into
school's
my...
doing, and the head teacher has a job duty to help them do it.
Well, my Lord, yes.
That's it, isn't it?
Yes, and my Lord, I'm just simply taking you to the statutory provisions that make good that perhaps rather obvious proposition. My Lord, the next provision which we've alluded to, but I just will take you to, is section 175 at page 383. Subsection 2, which is over the page on 384, provides that the governing body of a maintained school shall make arrangements for ensuring that their functions relating to the conduct of the school are exercised with a view to safeguarding, promoting the welfare of children who are pupils at the school. And by subsection 4, provision is made for the issuance of statutory guidance, and, my Lords, you've already seen the statutory guidance that was in force at the relevant time, Safeguarding Children and Safer Recruitment and Education, 2007. The relevant regulations are at tab 9 of the same bundle, page 428. Regulation 6 sets out the functions of the governing body. And my Lords will see that those are functions which are strategic in nature. Paragraph 4 sets out the head teacher's responsibilities, and they include internal organisation, management and control of the school. Subparagraph 5, the head teacher is accountable to the governing body for the performance of all his or her responsibilities. And by subparagraph 6, the head teacher must comply with any reasonable direction of the governing body. My Lords, I was going to take you to the guidance at this point, but you've already seen it. In my submission, that emphasises 3 critical points in respect of safeguarding. The first is that safeguarding is the responsibility of everyone that works with children. And of course, that is a proposition which applies with particular force to the head teacher of a school. Second, that safeguarding requires a precautionary approach, which has regard to the best interests of children. And third, the importance of information sharing. So, in answer to the question of whether or not the term can be implied into the contract of employment as the duty to disclose, we say it's both obvious and indeed necessary for the efficient running of schools. And we get that from the statutory provisions requiring the governing body to promote the well-being and to safeguard and promote the welfare of children at school. The role of the head teacher in being responsible for the day-to-day running of the school and effectively being the eyes of the ears of the head of the governing body in the school itself. Reinforced by those propositions that I derive from the relevant statutory guidance. And again, also reinforced in my submission by the Employment Tribunal's findings in respect of the job description and the disciplinary policy. Really, that's in the Employment Tribunal's decision at paragraphs 4.2 to 4.3 at MS 161. I don't think we need to turn that up again. That was something that my learned friend took the court to. So, in conclusion on whether or not there is an implied term to disclose, I say that's obvious and indeed necessary, and were it otherwise, a school could not properly run itself.
Okay, in principle, implied term to disclose, but implied term to disclose in what circumstances?
Yes.
bearing in mind the spectrum.
My Lord, that takes me to the next proposition 4, my Lord, which is really, as I understand, the nub of the dispute, certainly between myself and my learned friend, which is having accepted that there is an implied term or a duty in principle to disclose, does that, or was it reasonable for the employer to have determined that that covered the specific facts in this case? What I propose to do is threefold. Summarise the respondent's case first, turn then to take the court to the Childcare Act 2006 and disqualification regulations, which we say support our case on this point, and third, address the question of the appellant's knowledge and how the Employment Tribunal dealt with that. So taking each of those in turn then, our case in this respect is as follows. The starting point is that IS is deemed to be a risk to children in general. And we say that is apparent from the Employment Tribunal's reasons. Again, no need to turn up. It's at paragraph 4.5, MS 162, that he was convicted of making indecent images of children, which were graded from 1 to 4 on a scale where 5 was the maximum. And his sentence included a sexual offences prevention order, which prohibited him from having unsupervised access to children under the age of 18.
Well, that's the one that matters, isn't it? I mean, you've got, deemed is a slightly dangerous word, isn't it?
Quite.
People who are convicted of this offence may or may not actually pose a real risk of contact offences as distinct from viewing unpleasant material. But your point, as I understand it, is that it's because you don't know that you need to be talking about it. Yeah.
So the starting point is an assumption that he may well pose a risk.
Could.
Will
do, won't it?
Yeah. But that could comes from the very fact of his having been convicted of this offence and having been having a sentence, a specific sentence imposed on him that it was.
Well, the SOPO prevents him having contact with children under 18. In bald terms like that, did it?
Those are the findings of fact from
yes.
the Employment Tribunal.
All right, well, that's another issue.
Had they seen it? Had they seen the order?
Well, don't worry. The only thing that's troubling me is the framing of them when people are bound to bump into to children under 18 in all sorts of situations. But that's not an issue which affects anything that happens here, I don't think.
But stepping back from the precise terms of the order, in any event, he had a conviction for a sexual offence against children.
Well, but making indecent images of children is a bit misleading, isn't it? Because it includes viewing them.
Yes, he didn't. You must be careful. He didn't have a conviction for offences against children. He had a conviction for offences of viewing images of children. It's quite serious, and people get sent to prison for it. But it is not itself an offence of against individual children. It carries the real problem that those who make the pictures are abusing the children.
Well, my Lord, be that as it may, it is an offence which, for example, would automatically disqualify him
precisely
under the Childcare Act. So whatever the...
But we're not minimising it in any shape or form, but we want to be precise about things.
Well, my lady, I'm simply taking the language that was in the Employment Tribunal's decision. So the very fact of that conviction, coupled with his close relationship with the appellant, my submission meant that it was reasonable for the governing body to conclude that IS had at least the potential to be a specific risk to the children in the school. In terms of what that potential specific risk might be, it is that found by Lady Justice Black in the Court of Appeal, namely the possibility of access. So access to the school premises, access to information about school pupils. And of course, in a different case, albeit not this case, the possibility of grooming. That was accepted not to be applicable on the facts of this case. But the risk, or whether these were real risks as opposed to potential risks, and if so, what mitigation ought to be put in place in order to mitigate them, is the very thing that the governing body needs to decide for itself. And they were not matters that the appellant could appropriately or objectively determine for herself. Insofar as it may be said that the appellant wouldn't have let those things happen, or wouldn't have let the IS have access to the school or to information about pupils at the school, her level of insight into IS's conviction and what risk, if any, in consequence he posed to children in general, would have been critical matters for the governing body in determining whether in fact he did pose a risk to children at the school or not. But that was for the governing body to determine and not for the appellant to conclude for herself. Both Lord Justice Elias and Lord Justice Floyd below expressed concern as to what the parameters were to be placed on a duty to disclose a relationship with a sex offender. So Lord Justice Elias referred to there being a dangerous world of the mere association with the sex offender sufficed at paragraph 45 of his judgment, and Lord Justice Floyd considered there to be a spectrum of association and gave the example of a teacher with a distant relative in a different part of the country. And in my submission, the answer to that is, as Lord Justice Floyd held, whether association with a sex offender requires disclosure will always depend on whether a reasonable employer could reasonably have concluded that the relationship resulted in the potential for enhanced risk to the children in the school. And that is always a question of fact and degree. Having regard, as Lord Justice Floyd stated, to the very low threshold applicable in these cases, given the precautionary approach to be taken to safeguarding and the need to have regard to the best interests of children. In our case, at paragraph 114, Roman numeral 5, at page 102, I've set out the relevant factors that should be taken into account when determining whether or not a reasonable employer could reasonably have concluded that there was an enhanced risk, namely the closeness of the relationship between the employee and the offender. So, which of course is relevant to Lord Justice Floyd's point about distant relative, the physical proximity of the offender to the employee in their place of work, again relevant also to his example of the relative living in a far-flung corner of the country. The seriousness of the conviction, the circumstances of the conviction, and the date on which the conviction was obtained. So, without suggesting those are exclusive, those will certainly be relevant factors that go to the question of reasonableness. But the starting point is that this is a low threshold, having regard to the need for a precautionary approach to safeguarding. I emphasise that the question is whether the employer it was reasonable for the employer to conclude that on the facts of this case, the duty arose. The Employment Tribunal has concluded it's a question of fact. It was reasonable for the employer to so conclude, and that, in my submission, is a finding that an appellate court should be extremely slow to overturn.
Well, the appeal is only on a point of law, so we're not even in.
Quite.
into the territory of slowness to overturn. You have to identify a legal error in the finding.
My Lord, if my language is a little sloppy, I apologise. I meant to say that there isn't really a submission that that's a perverse finding by my learned friend.
No.
That is the territory in which he would have to pitch his claim.
Yes.
Making those points good, in my submission, is the Child Care Act 2006. In broad terms, the 2006 Act and the regulations made thereunder would have prohibited the appellant from working as a head teacher had she resided in the same household as IS, subject only to a waiver by Ofsted, but that would be a waiver for which she would have had to apply. Now, it isn't, I emphasise, any part of the respondent's case that these apply directly here. They were cited to the Employment Tribunal and no findings of fact about residing in the same property were made. We say, however, they're relevant for the reasons set out in our case at paragraphs 118 to 121, which is MS 103. But I want to emphasise just 2 points, if I may. The first is that the Act and the regulations demonstrate that Parliament deems there to be a risk arising from someone who lives with and therefore has a close association with a sex offender. No evidence of actual risk needs to be shown. That's simply assumed, again, subject to Ofsted granting a waiver. Second, whilst this isn't a case caught by the 2006 Act, it is a case in my submission that's very close to that paradigm, in that the appellant and IS jointly owned a home where she stayed on occasion and had other ways in which their lives were sort of intertwined in terms of her being on his car insurance, going on holidays together, and so on. The respondents have never suggested that it was inappropriate or improper for the appellant to associate with IS at all. Rather, all they have sought is disclosure of it. And I say, by analogy only, if she had been in the territory of the 2006 Act and the disqualification regs, she would have been completely precluded from working as a head teacher. Here, in a factual situation in which she bumps up against the parameters of that statutory regime, all that is being sought is disclosure of that relationship. And by analogy only, I say that supports the position of the governing body. My Lords, I should just take you through as shortly as I can, because it's not an uncomplicated piece of legislation, the Child Care Act and the regulations, just to make good those points.
So what are we looking for that we don't know?
My Lord, I'm so sorry.
What are we looking for that we don't know? They clearly have a duty to look after the children. Everyone accepts that. So what more do we need to know?
Well, my Lord, of course, I am responding to the case that's put against me, which is that the implied term that I say is in the contract to disclose doesn't apply on the facts of this case. Now, I've set out why it is that we say it does apply to the
Yes, I mean, you've made that point very good. And, your point is simple. The school is about looking after children. The head teacher is about doing that and helping the governors to do it.
Yes.
And so, if this was something which affected that duty, which obviously is an important question, then there's an implied term.
Yes.
One doesn't need lots of statutes to...
No, my Lord,
Well, you are going one stage further than that, aren't you? You're saying that these disqualification regulations are a straw in the wind.
yes. Well, my Lord, I think they do. They
I
do.
think you go further than that.
I think I go rather further than that.
You say, if we're looking at the spectrum
Yeah.
that Lord Justice Floyd has articulated in his judgment, we are very close, say you, to the first example at one end of the spectrum.
Yeah.
Quite.
I think that's the
Quite,
submission.
Quite. And the Act and the regulations make good that point, both of the fact of risk being assumed in respect of someone with the conviction that IS has, but also that Parliament has recognised that risk posed by someone in IS's position extends also to those with whom he may associate.
Yes, which is consistent with a precautionary approach.
My Lady, my Lords, the provisions are set out in my case. It's really a matter for you as to whether you wish me to take you through them.
Absolutely not. Thank you very much. The important thing is not what they say, because we know what they say. The important thing is what conclusions you draw from them.
Yes. My Lady, I hope that it is clear from the submissions I've just made as to the way in which I rely upon them. The third matter that I wish to deal with in terms of the fourth proposition is the appellant's knowledge. The Employment Tribunal found as a fact that the appellant knew that she ought to have disclosed her relationship with IS to the governing body. We say that's relevant, though again not determinative, of the reasonableness of the governing body's decision.
What paragraph of the decision, please, Ms. Hannett?
It's paragraph 26, my lord, and it's page 176. And my lord, it's to the bottom end of that paragraph. The claimant herself knew that she was subject to a duty to disclose because she would not otherwise have made inquiries as to the circumstances in which disclosure was triggered.
So she knew she was subject to a duty to disclose. That's not a finding that she knew she was under a duty to disclose in this case.
My lady, in the context of which the Employment Tribunal was making findings, and in particular in the context in which they draw that conclusion, it's apparent that that conclusion is drawn in respect of, or the inference is drawn from the appellant's conduct in asking and making inquiries of individuals as to whether or not she should disclose.
Ms. Hannett, I think you may be taking a bad point here. If you read the sentence that you've kindly referred us to, the claimant herself knew that she was subject to a duty to disclose because she would not otherwise have made inquiries as to the circumstances in which disclosure was triggered. Now, on your understanding of that finding, it's a complete non sequitur. She makes inquiries because she doesn't know whether she's under a duty to disclose. So I don't think we can take that as at face value, as you have invited us to do.
My Lord, perhaps I should just explain the context in which I'm making the submission, which may or may not be a good point, but it's in response, if I may say so, to that of my learned friend, who has maintained that the fact that the appellant has maintained throughout that she didn't know that she was under a duty to disclose is relevant to the consideration of reasonableness. So, it's in that context that I make the submission, in other words, that...
But the only point that we're putting is that you said baldly, the Employment Tribunal found as a fact that the appellant knew she ought to have disclosed to the governing body. And you mean that she knew she ought to have disclosed this information to the governing body.
Yes, my lady.
That is not what the finding in paragraph 26 is. That finding is that she knew she was under some duty to disclose, and she was making inquiries as to whether it applied in this particular case.
My lady, the only disclosure, of course, that's relevant in this case was that of her relationship with IS. I mean, the Employment Tribunal picks the point up again at paragraph 31, just halfway through that sentence. This is in the context of discussing Polkey and contributory fault. About halfway through, the Employment Tribunal say that the claimant had deliberately decided to withhold information from which she feared would have implications for her career, despite her recognition that the role of the governing body was that of a critical friend. So, my lady, I do say that there is a finding by the Employment Tribunal that the knew, and the basis for that finding was the inquiries that she made of various individuals as to whether or not she ought to disclose. Now, where that takes us is a slightly different point, because in my submission...
Well, paragraph 26 the sentence that's been read out and the following sentence, where she was concerned about the implications for her if the relationship was disclosed, might support the view that she knew that there were circumstances in which a duty of disclosure arose, and she knew that she might fall within those circumstances. But that's not going as far as saying she knew she wasn't doing so. She knew that she was failing in her duty to disclose. In the paragraph, in the sentence above the one we've been considering, it seems to me that we have the nub of the tribunal's reasoning, which is that it was obvious that this was information that they should disclose. So even if you haven't got a finding of actual knowledge, you've clearly got a finding that she ought to have known that this was what she should disclose.
And that was the finding of the dismissal panel.
Yes.
You ought to have known. And really, I make this point strictly in response to my learned friend to say that, of course, the question of whether the implied term applied on this specific facts isn't determined, or her knowledge, in other words, isn't determinative of that question. May be relevant, certainly not determining point. Lady, I was then going to move my submission, having dealt with the question of whether the implied term applies on the facts of this case, to deal, I think, relatively quickly, if I may, with Proposition 5, which is that the dismissal was within the range of reasonable responses open to the employer.
Well, do you wish to embark upon that now?
I don't think it's going to take me very long, but it may take me more than the 2 minutes that I have left on your
Well,
clock.
why
So perhaps
don't
better to
we
park that until
adjourn
after
now
lunch.
and look forward to hearing from you further at 2 o'clock. I think you're making reasonably good progress with your submissions.
Yes, I will be finished, I hope, well within my allotted time.
Thank you very much indeed. Court's now adjourned.